Hello everyone, welcome you all to Radheshyam Legal. In this video, we are going to discuss Introduction of CPC, which means Code of Civil Procedure 1908. The following are the contents which we will talk about now. The first one is meaning of CPC, then historical background, introduction, nature of the code, object of the code, and the scope of the code. So now let's start with meaning of CPC. Law relating to the practices and procedures to be followed in the civil courts is regulated by the Code of Civil Procedure 1908. To understand in a simple terms, for example, if there is a person X who is affected with a civil injury, what that person has to do? He had to file a case in a civil court. How? By filing a plaint. The entire process from filing a case through a plaint to getting a judgment or a decree in his favor, the entire practices and procedures which the person X had to be followed will be regulated by the Code of Civil Procedure 1908. Next, historical background. Till 1859 in India, there is no uniform civil law in civil codes. First time in 1859, a uniform civil procedure code was introduced by passing Civil Procedural Code 1859. It is a milestone, even though it had major limitations, so it was amended regularly from time to time, like in 1860, 1861, and finally it was replaced with a new version CPC 1877. Second Code of Civil Procedure 1877 was enacted with significant improvements and modifications, but still it didn't solve the needs. So another attempt was made in CPC 1882. This is a third CPC code. It remained for several decades, but as the social and legal needs were evolved, finally the current Civil Procedure Code 1908 was passed, overshadowing the defects of the Code of 1882. Next, coming to the current code, that is Introduction to the CPC 1908, which is a current code. The Code of Civil Procedure 1908 is a uniform civil code which is enacted by Imperial Legislative Council. It is passed on 21st March 1908 and came into force on 1st January 1909. This dates is very important, passed on 21st March 1908 and came into force, means every citizen has to be followed from 1st January 1909. And coming to the applicability, it extends to the whole of India. Every citizen who belongs to India have to be followed CPC 1908. There are total 158 sections in CPC 1908, which are divided into 11 parts, and total orders are 51. And this version of CPC 1908 is also amended several times. The major amendments are 1976, 1999, 2002. Here, it is very important to remember the enacted date, enforcement date, and total number of sections, and it is divided into how many number of parts, the number of orders, and also the major amendments. Here we will get a doubt of why we arrange these sections and orders separately, and this we will understand later in the nature of the code. Coming to the nature of Civil Procedure Code, The code is divided into two parts. First one is substantive law, second one is procedural law. This substantive law, which contains 158 sections, this substantive law says what the law is. It defines rights, duties, and liabilities. That means it will tell us what is legal and what is illegal. It also explains what people are entitled to. It sets penalties and also the remedies. And coming to the procedural law, it contains 51 orders. Procedural law says how the law is enforced. It explains the steps and processes used to apply substantive law. It will tell us how to file a case, how trials are conducted, how evidence is presented, how appeals are worked. Object of Civil Procedure Code. The main object of Civil Procedure Code is consolidation of laws. Consolidate means to combine or bring together multiple things into one unified whole code. This is just for clarity, efficiency, and consistency. Here, to consolidate and amend laws relating to the procedure and practices followed in the civil codes in India. The next one, speedy justice. To ensure quick and expeditious disposal of civil disputes without unnecessary delays. To avoid delays, to get a speedy justice is the main object of Civil Procedure Code. And the next one is equal justice, to provide equal opportunity to all parties for presenting their case fairly. Next, economical litigation, to make civil litigation less expensive and more accessible to common people. We all know litigation is very expensive. To make it less expensive, this unified code will be useful. Next one is certainty in procedure, to provide uniform and certain procedure for administration of civil justice across India. Next, finally, scope of Civil Procedure Code. To understand the scope of Civil Procedure Code, first you have to understand what is a special law or what is a local law. Special law means law made to deal with a particular subject or a class or a situation. It deals with only with a particular subject. The law is made to deal with only particular subject or a class or a situation. And the local law means it operates only in particular state or a region. And as this code is a general procedural code, it does not contradict with the local or special law which is in force. In the event of any conflict between the Civil Procedure Code and the special law, then the special law will prevail over CPC. In case the local or special law is silent on any matter which is very important, then the provisions of CPC will prevail. Thank you all. Bye.